Good day, everyone. Welcome to the pilot episode of BAReview 101, the channel for your accounting and law needs. So, for today's episode, we'll talk about meetings, religious corporations, and foreign corporations. So, to begin with, let's discuss meetings under Title 6 of the Revised Corporation Code of the Philippines, starting with Section 48. So basically, there are two kinds of meetings: the regular and special meetings of directors, trustees, stockholders, or members. Primarily, the chairperson of the board of directors, or in his absence, the president, will serve as the presiding officer of the meetings. According to Section 49 on regular and special meetings of stockholders or members, the regular meetings for stockholders or members are conducted annually on date fixed in the bylaws of the corporation, or if silent, on any date after April 15 of every year as determined by the Board of Directors or Board of Trustees. So for the BOD or the Board of Trustees and the Board of Directors, the time for the regular meeting is monthly unless the bylaws provides otherwise. The notice of regular meetings shall be sent to all stockholders or members of record at least 21 days, no? 21 days prior to the scheduled date, which has quite a difference to the old corporation code, which requires at least 2 weeks, no? Or at least 14 days prior to the scheduled meeting. However, this may vary from one corporation to another, no? Depending on what's written or required in their bylaws. So as for the special meetings naman of the stockholders or members, meetings can be scheduled anytime deemed necessary as provided in the bylaws of the corporation. For the BODs and or the trustees, special meetings are set anytime upon the call of the president as provided in the bylaws. For special meetings, there should be at least 1 week written notice, no? Unless a different period is provided in the bylaws or law or regulation. Take note, everyone, a stockholder or a member may propose the holding of a special meeting and items to be included in the agenda of the meeting. So the revision of the Corporation Code also integrates technological advances over the last 4 decades into the rules governing corporations. No? So the old code was enacted before the online age or even the widespread use of the personal computer in 1980s. The revised code allows written notices of regular stockholders meetings to be sent to all stockholders or members of record through email such as Gmail or Yahoo, which are the common, no? Common nga email ginagamit nato. Or such other manner as the SEC or the Securities and Exchange Commission shall allow under guidelines it would prescribe. So this is stated in Section 49 of the Revised Corporation Code. A corporation code is also allowed to specify in its bylaws the means of communication through which meetings would be sent. These include regular or special stockholders meetings, which are discussed in Section 50 on place and time of meetings of stockholders or members. Meetings to increase or decrease capital stock in Section 37, or to sell or dispose assets in Section 39, or to invest corporate funds in Section 50. So during every regular meeting of the stockholders or members, no, the BODs or trustees must present to the stockholders or members the minutes of the most recent, again, minutes of the most recent regular meeting, which includes all the important and necessary information formerly discussed and the resolutions reached or approved. Most importantly, the voting results or details from the previous meetings as well as the attendance. So BODs or the trustees should also present the list of members for both non-stock and stock corporations, their information and voting rights. BODs or the trustees must also disclose or share to the stockholders or members the assessment of the performance and any changes deemed relevant to the affairs of the corporation. So the BODs and or the trustees shall also endeavor to present the following information and documents of the corporation to the shareholders or members during meetings: certified financial statements, the internal controls or risk management systems, the statement of all external audit and non-audit fees, the explanation of the dividend policy, and reasons for non-payment thereof, profiles of directors or trustees, which includes the relevant personal information, the attendance reports, appraisals, and performance reports, director or trustee compensation report, profile of nominees or those seeking for election or re-election, and other transactions of the related parties. Okay, so the revised corporation code, no, or the revised code now allows members of the board of directors or trustees of every corporation to participate in meetings through remote communication, such as video conferencing, teleconferencing, or other alternative modes of communication, no, that will allow them to reasonable opportunities, no, that allow them reasonable opportunities to participate, no, which are stated at the last paragraph of Section 52 on the regular and special meetings of directors and trustees. No, here no, it's stated no, as stockholders or members may also be allowed to vote during stockholders meetings through remote communication or in absentia, but only if the corporate bylaws authorize voting through such means. So unsa man ni siya nga mga remote communications, no? We have this example, we have Zoom, Google Meet, no, which are utilized by a lot of companies and corporations in this time of pandemic, especially karon, no, that we are not allowed to have social gatherings, right? So the exception, as earlier mentioned, no, is in the case of corporations vested with public interest, where stockholders and members are entitled to vote to elect directors or trustees through remote communication or in absentia, even without a provision in the bylaws that authorizes voting through those means. Also, Section 49 also requires the Securities and Exchange Commission to issue the rules and regulations governing participation and voting through remote communication or in absentia. So, now proceeding with Section 50 on place and time of meetings of stockholders or members. So the stockholders and members meetings, whether it is regular or special meeting, shall be held in the principal office of the corporation, as set forth in the articles of incorporation, or if not applicable, in the city or municipality where the principal office of the corporation is located. So for example, no, the city or municipality where the principal office of Bato Corporation is located is stated in its articles of incorporation as Cebu City. So the principal office is specifically housed at the building located at Cebu Business Park, Cebu City. No? So thus, the meeting of the stockholders of Bato Corporation may be held in Metro Cebu, which for purposes of Section 50 is considered a city or municipality. However, if it would be practical, no, meeting will be held at Cebu Business Park, Cebu City. So Section 50 also talks about the notice of meetings. When we say notice, mo ni siya ang writing, no? The writing, no? It is the writing informing stockholders or the members of the meeting, which shall be sent through the means of communication provided in the bylaws. The notice must state the date, time, place, and purpose of the meetings. This includes already the agenda for the meeting and other information or requirements needed for the conduct of the said meeting. The notice of the meeting also, whether it is regular or special meeting, must be given to stockholders or members, since it is required by the Securities and Exchange Commission and when it is required by the laws of the corporation. All proceedings and any business transactions are transacted at a meeting of the stockholders or members, if within the powers of or authority of the corporation, shall be valid, even if the meeting is improperly held or called, provided that all stockholders or members of the corporation are present or duly represented at the meeting, and not one of them expressly states at the beginning of the meeting that the purpose of their attendance is to object to the transaction of any business because the meeting is not lawfully called or convened. So let's proceed. No? Under Section 51, a majority of the outstanding capital stock, or in case of non-stock corporations, a majority of the members shall constitute a quorum, unless otherwise provided in this code or in the bylaws of the corporation. In non-stock corporation, the basis for determining the quorum is the total number of registered members. And in the absence of quorum, no action can be taken except to adjourn the meeting. Again, in the absence of quorum, no action can be taken except to adjourn the meeting. Okay, so now the question is, who shall preside the meetings man, no? So section 53 of this corporation code provides that the chairman, or in his absence, the president, shall preside at all meetings of the directors or trustees as well as of the stockholders or members, unless the bylaws provide otherwise. So whenever, like for any cause, no person is authorized to call a meeting, the petitioning stockholder or member authorized by the Securities and Exchange Commission to call a meeting of the corporation shall preside, shall preside thereat until at least a majority of the stockholders or members present have chosen one of their number, as presiding officer of that meeting. So in stock corporations naman, the right to vote is an incident, of ownership of stock, of which the stockholder cannot be deprived without his consent, and he may vote as if he chooses, whether it be with the minority or the majority. So take note that voting rights will vary depending upon the class of stock that these stockholders have, no? So as for the non-stock corporations, the right of the members of any class or classes to vote may be limited to the extent specified, to the extent specified in the articles of incorporation or by the bylaws. Unless so limited or denied, each member, regardless of their class, is entitled to one vote. Okay, so now let's proceed to section 55 on voting in case of joint ownership of stock. So in case the shares of stock are owned jointly by two or more persons, section 55 of the revised corporation code requires the consent of all the co-owners in order to vote such stock. However, such consent is no longer necessary. Again, such consent is no longer necessary where first there is a written proxy executed, by the joint owners authorizing one or some of them or any other person to vote for all. And second, the shares are owned in an and in so the shares are owned in an and or capacity by the holders thereof, in which case any one of the joint owners can vote said shares or appoint a proxy therefore. So now in section 57 of the Corporation Code, it expressly denies any voting rights to treasury shares, no? So treasury shares as long as such share remain in the treasury. So these shares are not formally cancelled, no, and are therefore subject to reissue for the corporation at some future time. So such shares are not entitled to dividends. However, if such shares are reissued, no, it will regain whatever dividends and voting rights to which they were originally entitled. So now, for section 57, it also talks about the proxies, proxies. So as issued in this code, a proxy designates the formal written authority given by the owner or holder of the stock who has a right to vote it, or by a member as principal to another person as agent to exercise the voting rights of the owner. So this right to vote given to the proxy is a special form of agency, and the manner of voting is provided in the bylaws of the corporation. So under this section, under section 57, proxies must be in writing, signed by the stockholder or member, and filed before the scheduled meeting with the corporate secretary. So through the proxy form, ang kaning proxy form niya, it is attached in the notice of the meeting, no? And unless otherwise provided in the proxy, it is valid only for the meeting for which it is intended, no? So you can't use this proxy form for another meeting or scheduled meeting, no? However, if a proxy is continuing, he must be for a period not exceeding 5 years at any one time. Otherwise, it shall not be valid or effective after such period. Okay, so now let us proceed with section 58 on voting trust. Sometimes, no, it is desired to place the control of all or a part of our stock in the hands of one person or few persons. This is possible through this voting trust agreement. So the question here is, what is a voting trust agreement and what is it like, no? What is like to vote under such agreement? So voting trust agreement is an agreement in writing whereby one or more stockholders of a stock corporation transfer his or their rights, his or their shares, no, to any person or persons to a corporation having authority to act as a trustee for the purpose of vesting in such person or persons of our corporation as trustee or trustees, voting or other rights pertaining to the shares for a certain period not exceeding that fixed by the code and upon the terms and conditions stated in such agreement. So also under such agreement, no, title to the shares conveyed is now transferred to the trustee on the books of the corporation. Now, the question is, what really is the purpose of this voting trust agreement? So such agreement makes possible a unified control of the affairs of the corporation and consistent policy by binding the stockholders to vote as a unit. So it also makes it possible for a majority group of shareholders who transfer their individual holdings to a voting trustee to dispose of the beneficial interest, no, in a large proportion of their shares and still retain a control of the corporation. Okay, so now let's proceed, no, with Title 13 under the Special Corporations, no, of Chapter 2, which is pertaining to the religious corporations. Okay, so beginning with Section 107, no, under talks about the classes of religious corporations. So religious corporations may be incorporated by one or more persons, no? Such corporations may be classified into corporations sole and religious societies. So religious corporations shall be governed by this chapter, chapter 2, and by the general provisions on non-stock corporations and so far as applicable. So let's talk about corporation sole in section 108 or 108. For the purpose of administering and managing as trustee, no, the affairs, property, and moralities of any religious denomination, sect, or church, a corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, and other presiding elder of such religious denomination, sect, or church. So in order for us to have a better understanding of the corporation soul, I have divided the discussion to different parts. No, so first is the nature and the attributes of corporation soul. So a corporation soul consists of one individual endowed with corporate powers. When the incorporated person vacates the office by death, resignation, removal, or any manner, his successor in office becomes the corporation soul. This incorporated person thereby acquires by fiction being, which terminates when he dies, and his artificial or legal personality as a corporation, which survives him when he dies, no? And passes on to his successor in office, clothing the latter with a corporate personality, which by legal fiction is deemed to continue uninterrupted and unchanged. So the principal attribute of this corporation soul, therefore, is that of perpetuity. So perpetuity, it means that when a natural person dies, no, all of his properties pass on to his heirs under his will or to those named by the law as his heirs. So, and these heirs are usually those related to him by ties of blood relationship, where, however, this person has been constituted a corporation. So, whatever properties he holds rather in that capacity will pass, no, upon his vacating the office to the successor in office and not to their heirs, no, by nature or under the law. So in here, corporation soul, no, the person constituted as a corporation soul does not need a corporate name. No, again, a person constituted as a corporate soul does not need a corporate name and requires no peculiar seal. He does not need to keep records or minutes of his act and does not need any corporate bylaws to regulate his acts as a corporation. So most of the legal points governing ordinary corporations are not applicable to the corporation soul. Okay, so next is who may form corporations, no? Corporation soul in the Philippines. So the corporation law states that any religious denomination, society, or church may incorporate a corporation soul. So who may be incorporated as a corporation soul? So in here, no, the statute states that the person to be incorporated must be a bishop, chief priest, or presiding elder, duly elected or appointed as such in accordance with the rules, regulations, and discipline of the religious society. As evidence of his position, he is required to file a copy of his commission, certificate of election, or letter of appointment as such bishop, chief priest, or presiding elder. So it is not enough no, that the applicant for incorporation may be a duly appointed bishop, chief priest, or presiding elder. It is further required that under the rules, no, regulations, and discipline of his religious society, he must be charged with administration of the temporalities and the management of the estates and properties of the religious society within a definite um, territorial jurisdiction. Okay, sorry for that. Okay, so what is the purpose of this corporation soul, man? So, okay, the statute states that the purpose of incorporating a corporation soul in the Philippines is for the administration of the temporalities and the management of the estates and properties of his religious denomination, society, or church. So the corporation soul in the Philippines, no, guys, therefore is not concerned with any religious matters, but only with the temporalities, no? Which term includes the lands, the buildings, and other properties of a religious society, real and personal, as well as its revenues from its various sources of income. Okay, so now let's discuss the incorporation of this corporation soul. So under section 109, no, articles of incorporation, in order to become a corporation soul, the chief archbishop, the bishop, priest, minister, rabbi, or the presiding elder of any religious denomination, sect, society, or church must file with the commission the articles of incorporation setting forth the following. No? First, that the applicant is the bishop, the chief priest, or the presiding elder, as the case may be, of his religious denomination, society, or church, the name of which is usually mentioned, and that he desires to become a corporation soul. Second, that the rules, regulations, and discipline of said religious society are not inconsistent with his becoming a corporation soul, and that they do not forbid it. Third, that as such bishop, he is charged with the administration of temporalities and the management of the estates and properties of his religious society within his territorial jurisdiction. So their territorial jurisdiction must be described also, no? Next is the the manner of filing vacancies in the office to be incorporated according to the rules of the religious society. And lastly, no, the location of the principal office of the corporation so must be within the Philippines. Again, the location of the principal office of the corporation soul must be here, no, within the Philippines. Okay, so according to section 110, no, on the submission of the articles of incorporation of a sole corporation, no, the articles of incorporation must be verified by affidavit, no, or affirmation of the chief archbishop, bishop, priest, minister, rabbi, or a presiding elder, as the case may be, and accompanied by a copy of the commission, certificate of election, or letter of appointment of such chief archbishop, bishop, priest, minister, rabbi, or presiding elder, duly certified to be correct by any notary public. Okay, so guys, there's one question, no? Can corporations sole purchase or hold real estate and personal properties? So the answer here is yes. According to section 111, no, or 111, under the acquisition and alienation of property, a corporation sole may purchase and hold real estate and personal property for its church, charitable, benevolent, or educational purposes, and may receive bequests, no, or gifts for such purposes. Okay, so now what happens if there is a vacancy of position or vacancy in the office, no? So section 112, no, or 112 states that during any vacancy in the office of chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church incorporated as a corporation sole, the person or persons authorized by the rules, regulations, or discipline of that religious denomination, sect, or church represented by the corporation sole to administer the temporalities and manage the affairs, estate, and the properties of the corporation sole shall exercise all the powers and authority of the corporation sole during such vacancy. Okay. So now the question is what happens mano? What happens during the dissolution of a corporation sole? So section 113 or section 113, no, here it's stated here, no, nga a corporation sole daw may be dissolved and its affairs settled voluntarily by submitting to the commission a verified declaration of dissolution, setting forth first we have the name of the corporation, second the reason for the dissolution on or the winding up, third the authorization for the dissolution of the corporation by a particular religious denomination, sect, or church, and lastly the names and addresses of the persons who are to supervise the winding up of the affairs of the corporation. Upon approval of such declaration of the dissolution by the commission, the corporation shall cease to carry on its operations except for the purpose of winding up its affairs. Okay, so now we're already reaching now to the last topic, no, which are foreign corporations under Title 15 of the Revised Corporation Code of the Philippines. Okay, so um, under Section 140, no, here foreign corporations are formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in its own state or country. So a corporation established under the laws of the Philippines, no, is a domestic corporation with respect to the Philippines, and a foreign corporation with reference to another state. So if corporation is organized under the laws of another country or another state, it is domestic with reference to the said country, and a foreign corporation under the Corporation Code of the Philippines. Okay, so um, under section 123 or section 123, no, foreign corporations shall not be permitted to transact or do business in our country until they have secured a license for that purpose from the Securities and Exchange Commission. Again, they should secure a license, no, from SEC, and a certificate if certificate if authority from the appropriate government agencies. Okay, so na yung mga business permits, kana siya, when it comes to sa BIR, mga nila, di ba, for the taxes. Okay, so thus, in connection to this section of this corporation code, no, section 141 further states, no, further states that the application to existing foreign corporations, no, for every foreign corporation which on the date of the effectivity of this code is authorized to do business in the Philippines, no, under a license issued to it, shall continue to have such authority under the terms and conditions of its license. Okay, so now the question is, how can foreign corporations apply for a license in order to transact or do business in our country. So according to section 142 no, of the new or the revised corporation code, which is in section 125 of the old corporation code, na a foreign corporation daw applying for a license to transact business in the Philippines shall submit to the commission a copy of its articles of incorporation and bylaws, certified in accordance with law and their translation to an official language of the Philippines, if necessary. Okay, so the application shall be under oath and unless already stated in its articles of incorporation, shall specifically set forth the following. So, first, the date and the term of incorporation. Second, the address, including the street number and the principal office of the corporation in the country or state of incorporation. Third, the name and address of its resident agent authorized to accept summons and process in all legal proceedings and all notices affecting the corporation, pending the establishment of a local office. Fourth, the place in the Philippines where the corporation intends to operate. Okay? And fifth, no, the specific purpose or purposes which the corporation intends to pursue in the transaction of its business in the Philippines, provided that the said purpose or purposes are those specifically stated in the certificate of authority issued by the appropriate government agency. So next, no, the names and addresses of the present directors and officers of the corporation. Next, a statement of its authorized capital stock and the aggregate number of shares which the corporation has authorized to issue. The itemized, it should be itemized by class, the par value of shares, shares without par value and series, and if any, a statement of its outstanding capital stock and the aggregate number of shares which the corporation has issued. No, itemized by class, par value of shares, shares with without par value and series. If any, also a statement of the amount actually paid in, and lastly, such additional information as may be necessary or appropriate in order to enable the Commission to determine whether such corporation is entitled to a license to transact business in the Philippines and to determine and assess the fees payable. Okay, so a certificate under oath is also attached to the application for license, stating that the applicant is in good standing. Again, the applicant must be in good standing and capable of transacting business in our country. So, which means that the applicant is in sound financial condition, no? Na siya ability or capability to pay all the kind of mga finances or mga liabilities niya if ever. Okay. So now let's proceed with section 143 no, of the revised corporation code. So this pertains to the issuance of a license. Okay. So if the commission is satisfied that the applicant has complied with all the requirements of this code and other special laws, rules, and regulations, the commission no, shall issue a license to transact business in the Philippines to the applicant for the purpose or purposes specified in such license. So upon issuance of the license, such foreign corporation may commence to transact business in the Philippines and continue to do so for as long as it retains its authority to act as a corporation under the laws of the country, which is the Philippines, or state of its incorporation, unless such license is sooner surrendered, revoked, suspended, or annulled in accordance with this code or other special laws. Okay. So now, the question, no? What are the effects if foreign corporations perform business without a license? Meaning, no, kani sila mga illegal ng mga transaction, no? So, according to Section 150 of the Revised Corporation Code, Section 150 states that the foreign corporation transacting business without a license or its successors or assigns shall not be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency of the Philippines, and such corporation may, however, be sued or proceeded against before Philippine courts or administrative tribunals on any valid cause of action recognized under Philippine laws. Okay, so The licenses of the foreign corporations may also be revoked or suspended by the commission upon any of the grounds for revocation, for revocation provided in section 151 of the revised corporation code. So, pursuant to section 150, such foreign corporation can no longer transact business in the Philippines, and it cannot maintain any suit or action in any court or administrative agency in the Philippines, although it may be sued on any valid cause of action. So, furthermore, contracts entered into by this foreign corporation after the revocation of the license are invalid and deemed unenforceable. So as to such contracts, the effect is the same as if a license have never been granted, have never been granted to it or to that um, foreign corporation. Okay, so that concludes our discussion for today. I hope that you guys learned something new, and for kanang more reference, you can check the revised corporation code matrix on Google, so you can have a clear comparison, or you can see the difference from the old corporation code from the revised corporation code. So thank you guys, and once again, good day. My name is Gerald Nitz Ponce. Take care and keep safe.